Everyone, for those that are just joining, we're just starting a little bit late, just a bit of a delay with a tech issue with the link. So hopefully we're just waiting for a moment just to see more people that can come in, and then we'll crack on. I think maybe we should just get going, and then when people come in, we can move forward.
Okay. So yeah, thanks everybody for joining. My name is Matteo. I'm the campaigns manager for Reunite Families UK. We are a UK-based organization helping families navigating the UK spouse visa rules, which now sadly also include EU citizen following Brexit. And so the idea of this webinar, thanks to Fragomen for helping us with this, is to help people understand the various family schemes applying to EU citizens based on their circumstances. And before I pass on the word to Fragomen, I just would like briefly to introduce and ask them for a quick introduction to Kezia from the 3 Million, and then I'm not sure who joined from Seto.
Yes, it's me, Eva from Seto.
Okay, so Eva, if you can speak after Kezia to briefly introduce your organization as well. Thank you.
Hi there, thanks Matteo. Hi, good to see so many of you here for this very important topic this afternoon. I'm Kezia Tobin, I'm the Head of Policy and Advocacy at the 3 Million. Just a little bit of background into who we are as an organisation. We are an advocacy organisation that lobbies for the better protection of EU citizens' rights and the rights of their family members in the UK post-Brexit. Unlike many of you and unlike Settled, we are not immigration advisors, so we don't do immigration casework. We do advocacy in terms of government advocacy work, and also we're involved in strategic litigation and that sort of thing. And all of the work that we do as an organisation is informed by the case examples that come to us. So people come to us to let us know about difficulties that they're having accessing their rights, accessing their status, and they come to us in a variety of different ways, and it's that really informs what sort of policy priorities we take forward in our advocacy work. So I'd just like to use this opportunity as a bit of a plug, because I know that you're all here because you work with people who are potentially encountering difficulties with the EUSS. And so we would really welcome hearing from you as professionals and from your clients on a personal level. Please get in touch if you come across systemic issues or recurrent problems. We'd really like to hear about them, and it really does make a difference to the work that we prioritise. So you can contact us by email. There's also a report it tool on our website that I'd really urge you to spread the word about, because through people reporting their problems on that through that tool, it helps us to find out what sorts of issues are most pressing for the most number of people at the moment. I also just very briefly said that I would do a quick plug as well for another survey that's out at the moment, the Independent Monitoring Authority, the IMA, which monitors the government's implementation of the withdrawal agreement, is currently carrying out their third annual survey to find out what issues are most pressing for EU citizens' rights. So if you can take a look at that as well, or encourage people to go and respond to that survey, that again will inform the priorities that the IMA chooses to focus on in the next few months. Thanks, Matteo.
Thanks. Eva?
Thank you. So, like Kezia has said earlier, we are a charity giving advice. Settled. It's mostly for EU citizens and their family members, so we are limited by our charitable objectives to only provide immigration advice on EU settlement scheme. So we help mostly with late applications and refusals at the moment, and we also provide advice for joining family members. Our advice service is free, it's multilingual. We mostly provide advice via email and via helplines. We also have a couple of Facebook forums where we provide one-off information or simple advice. And since last year, we also provide advice on Ukraine schemes. So for anybody who has a family member with a Ukrainian passport, we can provide advice on that as well. And we also provide advice to hosts as well as the Ukrainians. And I think that would be a brief introduction for us. And I just wanted to say that I can see a couple of our volunteers on this call, and it's great to see them here. Thank you.
Thank you so much, Eva. And I think now is the turn for Sharon to begin the webinar from Fragomen. So thank you so much again for Fragomen for their help.
Thank you, Matteo. We're just going to share some slides. Katie, do you want to bring them up? So thank you all for attending this webinar on Appendix EU, more specifically pre-settled status under the EU settlement scheme and also EU settlement scheme family permits. On this webinar, we'll be focusing on family members of EEA and Swiss nationals and how they can apply under the EU settlement scheme. We'll give an overview of the EU settlement scheme and also EU settlement scheme family permits. We will discuss the differences between EUSS applications and applications under Appendix FM. We'll also run through who is a relevant EEA citizen and options for their family members, which includes family permits. We'll also give an overview of unusual applications under Surinder Singh, Luns and McCarthy. And finally, we'll give an overview of the application process for family permits and the pre-settled status, and also applications for people already in the UK. So if we go on to the next slide, I'd just like to introduce you to the team from Fragomen that are here with you today. So I'm Sharon Muir, I'm a senior manager at Fragomen. We also have Jenny, Ozaro, Jan, and last but not least, Katie. So we do have quite a bit to get through today, and we are recording the session. So if you'd like to ask a question, there should be a time at the end, or you can pop the questions into the chat, and we'll run the Q&A at the end for you. So moving on to the next slide. So as a result of Brexit, the UK government introduced the EU settlement scheme through Appendix EU of the UK immigration rules as a way to safeguard the rights of residents of EEA and Swiss nationals and their family members in the UK. The EU settlement scheme allows EEA and Swiss nationals and their family members to apply for an EUSS family permit, pre-settled status and settled status. And we'll also touch on EU settlement scheme travel permits. So the EU settlement scheme allows you to live, work and study in the UK, and means that you are eligible for public services, such as healthcare and schools, public funds and pensions, and also you might be eligible to apply for British citizenship if you'd like to apply and you also satisfy the requirements. So who is eligible to apply for pre-settled status? So if you're from the EEA or Switzerland and you started living in the UK before the 31st of December 2020, then you can apply for pre-settled status. Or if you're the family member of someone from the EEA or Switzerland who started living in the UK by the 31st of December 2020, who either has pre-settled status or settled status or has a pending application. There are other categories of people that may be eligible to apply, for instance, a family member of an eligible person of Northern Ireland and family members of British citizens. I'm not going to go into details for them at this point, as Jan and Jenny will touch on this later on in the webinar. I'll also discuss who family members are a little later on. So just moving on to the next slide, the deadline for most people to apply to the EU settlement scheme was the 30th of June 2021. However, you still may apply if you or your family member were living in the UK by the 31st of December 2020. And if either a later deadline applies to you or you have reasonable grounds for not applying by the deadline. So there are separate deadlines for non-EU family members living overseas. So for example, if you are a non-EEA or Swiss family member of a person who has pre-settled or settled status or has applied for either, and your relationship began before the 31st of December 2020, and you remain a close family member. Other circumstances are that you're a family member from the EEA or Switzerland living in the UK before the 31st of December 2020 with settled or pre-settled status, and you joined them in the UK on or after the 1st of April 2021. Also, if you're a child applying who was born or adopted in the UK on or after the 1st of April 2021. Also, if you're a child from the EEA or Switzerland and have lived in the UK since the 31st of December 2020. Also, if you're exempt from immigration control or you stopped being exempt from immigration control after the 30th of June 2021. Another example is if you are in the UK with limited leave to enter or remain. For example, you're here on a work or a study visa, which expires after the 30th of June 2021. Also, if you're, as mentioned before, you're a family member of a British citizen and you've lived in the EEA or Switzerland, and also if you're the spouse or a civil partner of a Swiss citizen, you can apply until the 31st of December 2025. So moving on to the next slide. If you didn't apply by the 30th of June 2021 or by the deadline for your circumstance, if it's later, you may still be eligible to apply under the scheme. You'll need to have reasonable grounds for why you didn't apply by the deadline, and there are many different reasons that can be included as reasonable grounds for not applying by the deadline. This is by all means not a complete list. If you have a reason that's not listed here, you can still apply and your reason will still be considered by the Home Office. So some reasonable grounds are, for example, if you had permanent residence status or a residence document that stopped being valid after the 30th June 2021 and you didn't know that you had to apply under the scheme. Or if you were a child or applying on behalf of a child and you didn't know that you needed to apply, or that you have or had a medical condition which prevented you from applying at the time. I'm now going to hand over to Katie, who's going to give you a quick overview of an EU-SS family permit.
Thank you, Sharon. So another type of application you may wish to make is the family permit. This just makes it easier to travel to the UK. So if you are successful in applying for the travel permit, you'll be able to join a family member in the UK, and you can then leave and re-enter the UK for a period of 6 months, starting from the date the decision was made on your application. You'll be eligible to apply for the family permit if you are the family member of somebody who is an EU national, a Swiss national from Norway, Iceland or Liechtenstein, or if you're the family member of an eligible person from Northern Ireland. You may also possibly apply if you have a British citizen as a family member. Another type of permit you may apply for, this is different from the family permit, although it does also make it easier for you to travel to the UK. The travel permit allows non-EEA nationals who already have settled or pre-settled status under the scheme to re-enter the UK in the case where their BRP card has been lost, it's stolen or it's expired. So you can apply for the travel permit if you are not an EU national or from Switzerland, Norway, Iceland or Liechtenstein, and you already have settled or pre-settled status under the scheme, and you must have already reported your BRP card to be lost, stolen or expired. So you can apply for this travel permit online, and you will need to attend a biometrics appointment. So your application will be made outside the UK and you'll attend your appointments outside the UK. If you're successful, then this will grant you permission to leave and re-enter the UK for a period of 6 months again from the date of decision on that application. So I'm just going to hand over now to Jenny to talk about the next slide.
Thank you, Katie. In this part of the presentation, I will be highlighting the key differences between the EU settlement scheme and the applications under the Appendix FM that we ran through with you last time. So regarding the sponsors, under the Appendix FM, the sponsor must be a British or Irish citizen or someone who has settled in the UK. For example, they have indefinite leave to remain in the UK. Other circumstances include the sponsor having protection status, being a refugee, or having humanitarian protection. Under the EU settlement scheme, the sponsor is someone from the EU, Switzerland, Norway, or Iceland or Liechtenstein. They can be an eligible person of Northern Ireland or some British citizens in certain circumstances. And my colleagues will be talking you through this further in the slides to come. Regarding the applicants, under the Appendix FM, the applicants are individuals who are non-European nationals, so they can be spouse, civil partner, or unmarried partner of the sponsor. They can be fiancé or proposed civil partner, or a child, normally under 18 years old for an out-of-country application. The applicant can also be a parent or a relative who will be providing long-term care to the sponsor in the UK. However, in the last two instances, a high threshold must be met in terms of eligibility for the application. Under the EU settlement scheme, the applicant can be a family member of someone from the EU, Switzerland, Norway, Iceland, or Liechtenstein, including those with dual nationalities. They can be a family member of an eligible person of Northern Ireland or of a British citizen in certain circumstances. The applicant can be a spouse, civil partner, or unmarried partner of the sponsor. They can be a child or grandchild or great-grandchild under 21 years old, or a dependent child or grandchild or great-grandchild over 21. Or they can can be a dependent parent or grandparent. And again, my colleagues will be talking you through further in detail regarding the sponsors and the applicants. So I will now be handing over to Jan to talk you through further regarding the EEA citizens, and my colleague Sharon later on to explain further the family members. Thank you.
Thank you, Jenny. So I'll now expand further on who are considered relevant EEA citizens under the EU settlement scheme. So relevant EEA citizens include EEA nationals. So EEA nationals include EU nationals and nationals from Iceland, Liechtenstein, and Norway, and also Swiss nationals in the same category. So these nationals are considered relevant EEA citizen under the EU settlement scheme if they have either been granted free settled or settled status under the EU settlement scheme, or they have made a valid application under the scheme and are awaiting a decision to be made, or they have exercised free movement of rights in the UK before acquiring British citizenship, whilst retaining their EU nationality, also known as dual nationality applicants. Relevant EEA citizens also include Northern Irish nationals who meet all of the following requirements. So the first requirement is by having a birth certificate, which shows that they were born in Northern Ireland and at least one of their parents was a British citizen, Irish citizen, or were entitled to reside in Northern Ireland without any restrictions, when the Northern Irish national was born, and then meet the criteria to apply for pre-settled or settled status under the EU settlement scheme without needing to make an application, as Northern Irish nationals do not need to make an application in order to stay in the UK, as Northern Ireland is part of the UK. And finally, Irish nationals are also considered relevant EEA nationals under the EU settlement scheme, as long as they meet all the criteria to apply for pre-settled or settled status under the EU settlement scheme. And similarly to Northern Irish nationals do not also need to make an application because they are also entitled to reside and work in the UK under a separate agreement with the UK. Next slide, please, Katie. So what are the options for family members of relevant EA citizens with a pending application? So earlier in my previous slide, we just mentioned that relevant EA citizens also include nationals, EA nationals and Swiss nationals who have made an application under the EU settlement scheme and are pending an application. So as long as they have submitted a valid application under the EU settlement scheme, a family member would still be eligible to apply for an EU settlement scheme family permit by making a reference to the relevant EEA citizens' submitted application. So as long as the relevant EEA citizen has submitted an application, they could use the reference number that was provided in the submitted application in order to make the EU settlement scheme family permit. Once an application is approved, the family permit is usually valid for 6 months. I will now hand over to my colleague Sharon to give you an overview of the EU-SS family permits. Thank you, Sharon.
Thank you, Jan. So who are considered family members that can apply under the EU settlement scheme? So Jenny's already been through a few of these already, but I'll whiz through them again for you. So a family member of an EEA or Swiss citizen includes the spouse, civil partner, or if you're in a durable relationship, and I'll go into the definition of a durable relationship in more detail on the next slide. Child or grandchild under 21, dependent child or grandchild over 21, dependent parent or grandparent, and it also includes family members who were adopted. So the family relationship must have begun by the 31st of December 2020. And if you're married or in a civil partnership with a Swiss citizen, you may be eligible if you were married or entered into the partnership any time before the 1st of January 2026, and the relationship is still ongoing. The relevant EEA or Swiss citizen was living in the UK by the 31st of December 2020. And the relevant EEA or Swiss citizen will be in the UK when you apply, or will travel there with you up to 6 months later. The relevant EEA or Swiss citizen must usually have settled or pre-settled status, or have applied and are awaiting a decision. So the documents that you need to provide as evidence of the relationship. So if it's a spouse, if you're the spouse or the civil partner, it will be a marriage certificate or a civil partnership certificate, or a document issued under the EEA regulations showing the relationship, for example, a family permit or residence card. And also be aware that if you're married, or if you were married or formed a civil partnership after the 31st of December 2020, you'll be required to show evidence of a relationship before that date. So if we move on to the next slide. So we've covered spouses and civil partners, but what is considered a durable relationship? So this differs to Appendix FM's definition of an unmarried partner. Appendix FM is when you apply as a spouse, civil partner, or unmarried partner of a British national or someone settled in the UK. Appendix FM is strict in its interpretation, so the unmarried partners must have been living together, akin to marriage, for at least 2 years prior to the date of application. But under the EU settlement scheme, including family permits, the couple must have been living together in a relationship akin to marriage or a civil partner for at least 2 years, or more importantly, there must be other significant evidence of the durable relationship. So if you've been living together in a relationship akin to marriage or civil partnership for at least 2 years, the types of evidence that you'll need to provide are bank statements or utility bills in joint names at the same address, your residential tenancy or rental agreements or mortgage statements, and any other official correspondence going to the same address. For example, letters from employers, hospital, doctors, university. So what are examples to show significant evidence of a durable relationship? So showing joint custody, responsibility for a child, birth certificate or a custody agreement showing the couple are cohabiting and sharing parental responsibility. Evidence of joint finances, joint businesses or joint commitments. So for example, tax returns, business contracts, investments. Evidence of regular communication and visits while living apart, alongside definite plans concerning the practicalities of living together in the UK. And if you're unable to live together as an unmarried couple due to religious or cultural norms, the relationship must still be similar to marriage or civil partnership. So evidence of regular communication, visits, holidays, events that you've attended together, financial support of one another, joint care of any children that you have together. And it really needs to be more than just a boyfriend-girlfriend situation. If we move on to the next slide. So I'm just going to skip quickly through this one. So you may also apply under the EU settlement scheme if you're a family member of a British citizen or an eligible person of Northern Ireland, as Jan has gone through. And you may also apply if you're a family member of a frontier worker. So now I'm going to hand over to Jenny, who's going to go into a bit more detail on the unusual applications.
Thank you, Sharon. So the principle established from the judgment of the European Court of Justice in the Surinder Singh case is that in certain circumstances, a British citizen could be treated the same way as a citizen of another EEA member state for the purpose of exercising freedom of movement to take employment in the UK. And to be eligible, the British citizen, the sponsor, would need to have exercised EEA treaty rights through employment or self-employment in another EEA member state. What this would mean in practice is that the non-EEA family member, the partner of the eligible British citizen, would then benefit a lot more from a favorable EEA right to free movement. And in terms of the main criteria for such an application, the applicant must be the family member of the British citizen who is the sponsor. The applicant must be currently living with the British sponsor in an EU country or Switzerland or Norway or Iceland or Liechtenstein by the 31st December 2020, or the applicant was born or adopted there since then. The British sponsor will be in the UK at the time of the submission of the application, or will be traveling with the applicant up to 6 months later. So these are the main criteria for an application under the principle of the Surinder Singh case. Another two unusual applications are the Lunes or Lunes and McCarthy, and these cases are concerning EEA nationals with dual nationality. So under the principle of Lunes, the European Court of Justice established that or held that family members of EEA nationals are able to derive the EU law rights after their EEA national family member has naturalized in the host member state. So this principle applies where the EEA national has exercised the treaty rights by moving to and residing in the host member state other than their country of origin, where they are, which they are a national of. And then they have acquired the nationality of the host member state while retaining their original nationality, so holding dual nationality. And several years later, they marry a third country national with whom they reside in the member state. So the main criteria for such an application are that the sponsor started living in the UK by the 31st December 2020. They have acquired British citizenship, and they still retain their citizenship from the EU or Switzerland or Norway, Iceland or Liechtenstein, and they lived in the UK using their free movement rights before acquiring the British citizenship. So that is the Loon's case. In terms of McCarthy, the European Court of Justice held that Ms. McCarthy, who is a dual Irish and UK national, and her non-EEA national spouse, and in her case is Jamaican, couldn't rely on EU law as she had never exercised a right of free movement, having not lived elsewhere in Europe. The main criteria for such an application are that the sponsor started living in the UK by the 31st of December 2020. They have acquired British citizenship, and they still retain their original nationality with an EU country, Switzerland, Norway, Iceland, or Liechtenstein, and they settled in the UK before the 16th of July 2012 without using their free movement rights. And last but not least, on the 16th of July 2012, they had either a right of permanent residence in the UK, or they held a document issued under the EEA regulations, for example, a residence card. So these are the three unusual applications. So if you have an applicant in this situation, you could refer to us and we could advise you further. I will now be passing this on to my colleague to take you further, Katie, to take you further the application process for a family permit application under the EU settlement scheme. Thank you, Katie.
Thanks, Jenny. So to apply for a family permit under the settlement scheme, it's free to apply. Once you have submitted your application, we expect it to take 15 working days from the date of your appointment or the date you submitted your application using the ID Check app. If you have a valid current BRP or you are an EEA national, you will be able to apply using the app. Otherwise, if you don't hold a BRP or you're not an EEA or Swiss national, you will need to apply online and attend a biometrics appointment at a visa application centre. Your application will need to be submitted from outside the UK. And if you are successful, as previously mentioned, this will grant you leave in the UK for up to 6 months, and during that time you will be able to work and study in the UK, and you can leave and re-enter as many times as you wish. So just handing now over to Jan.
Thank you, Katie. I'll now give an overview on the application process for family members of relevant EEA citizens to apply for pre-settled or settled status when they arrive in the UK. As Katie mentioned, the EU settlement scheme family permit is only valid for 6 months. Therefore, if the family member of the EEA citizen wishes to continue residing with the EEA citizen in the UK, a further application will need to be made. And this is generally the pre-settled or settled status application under the EU settlement scheme. The general deadline, as mentioned by my colleague Sharon, to apply for pre-settled settled status is 30th June 2021. However, this deadline does not apply to family members joining relevant EEA citizens on or after the 1st of April 2021. Although this deadline does not apply, the family members must still apply for pre-settled or settled status within 90 days from the date of arrival. Therefore, although the visa is valid for 6 months, if you've entered on a certain date, you have 90 days to make a further application to continue residing in the UK with your EA citizen family member. If the deadline is missed, so if the 90-day deadline is missed, the family member could still apply if they can show reasonable grounds for why they did not apply on time. Reasonable grounds can include medical condition, or if the person is in an abusive relationship, or there are other compelling or compassionate reasons why they couldn't make the application in time. So I'm just going to provide a very the mandatory required documents to make the pre-settled or settled status application in the UK. This is a non-exhaustive list, and the government can always request for further documents in their discretion. So the main documents required for this application is, of course, the proof of identity. This would be your passport, and also the EU settlement scheme family permit, and evidence of eligibility to apply after the 30th June 2021 deadline. This includes inbound travel tickets to show that you have traveled into the UK within the validity period of your EU settlement scheme family permit, and evidence to show the relationship the family member has with the relevant EA citizen family member. So for a spouse, it could be a marriage certificate or a civil partnership certificate, and for a child, it could be a birth certificate. And for parents, for example, it would be your birth certificate showing that your parents are your parents. And then finally, the relevant EA citizens' immigration status in the UK. So if they have submitted an application and it's approved, they would have a settled status or pre-settled status. It's a digital status to show that they have the immigration status they have in the UK. If they've submitted an application and it's still pending, they will receive something known as the certificate of application, which the family member could use to make a reference to the EU citizens' submitted application when they make their pre-settled or settled status application in the UK. And now moving to the next slide. Katie, thank you. So the processing time for the EU settlement scheme on the government website, it is published for 6 to 8 weeks, but it could take up to 6 months based on recent and practical experiences that some of us have had with this application. So it could take longer than the published timelines. However, it's not always an issue, because once the application is submitted, you will be issued with a certificate of application, which is something you can use to prove your immigration status in the UK, and also is also a certificate that you could use to travel in and out of the UK as long as it's still valid while your application is still pending. So once the application is approved, you will get a decision issued by email or by post, confirming whether you have been granted pre-settled status or settled status. So if an individual is granted pre-settled status, they can reside in the UK for 5 years from the approval date of the decision letter. And once they have resided in the UK for 5 years and not being absent for more than 6 months in a 12-month period, they'll be eligible to apply for settled status. If you have been granted settled status, you can reside in the UK permanently, and you can also apply for British citizenship after 12 months on the settled status. So now I'll hand over to my colleague Jenny to talk about applications for people who are already in the UK. Thank you.
Thank you very much, Jan. So my colleagues, Katie and Jan, have just talked you through the application process for a family permit application and an application for pre-settled status under the EU settlement scheme. So now I'm going to move on to the application for someone who's already in the UK. So a person in the UK may be able to apply for an EU settlement scheme family permit if they previously had the right to live in the UK through an eligible family member, but then their family member has died, left the UK, or the relationship has broken down, and this is called having retained the right of residence. So in terms of eligibility, let's have a look at the sponsor and the applicant. Regarding the sponsor, this can be a citizen of an EU country, or Switzerland, or Norway, or Iceland, or Liechtenstein, who was living in the UK by the 31st of December 2020. Or the sponsor can be a British citizen who was living in the UK, who was living with the applicant in the EU, Switzerland, Norway, Iceland, or Liechtenstein by the 31st of December 2020. Regarding the applicant, an applicant may have retained the right of residence if the eligible sponsor died. The applicant is their child, and the sponsor died or has left the UK, and the applicant themselves is in education in the UK. Or the applicant can be someone who has had a child with the eligible sponsor, but then the sponsor died or has left the UK, and the child is in education in the UK. Where the relationship has broken down, so then the sponsor divorced the applicant or a family member of the applicant. Sorry, can we go back to the previous slide? Yeah, thanks.
Sorry, Jenny.
That's okay. In another scenario, the relationship may have been broken down permanently because of domestic violence or abuse. So in all, the applicant must also have lived with the sponsor, the eligible sponsor in the UK before the eligible sponsor died or left the UK or before the relationship broke down. So that is the eligibility of the sponsor and the applicant. Thank you, Katie. So regarding the documents for the applicant to provide for such an application, let's have a look at the proof of identity and the additional documents. Regarding proof of identity, the applicant must provide a valid passport, or if they come from the EU, Switzerland, Norway, Iceland, or Liechtenstein, then they can produce a valid national identity card. Regarding the additional documents, this is the list of documents that must be provided. It's not an exhaustive list, but these are the key documents that they need to provide additionally in support of their application. So the sponsor's valid passport or valid national identity card if they are from EU, the EU, Switzerland, Norway, Iceland, or Liechtenstein. They need to provide evidence of the applicant's relationship to the eligible sponsor, for example, a marriage certificate or civil partnership certificate, if the applicant is the partner or the spouse, or a birth certificate if the applicant is a child. Evidence that the applicant has been continuously a resident in the UK. So evidence of their residence in the UK. These can vary from bank statements, council tax bills, energy bills, and in terms of residence, they can evidence this by way of their passports for the period of their residence in the UK. Where the sponsor has died, so then the applicant will need to produce the death certificate, the cause of death, the evidence of the sponsor's UK residence in employment prior to their death. the applicant, where the applicant is a child or has had a child with the eligible sponsor. So then they need to evidence the fact that the child is in education in the UK, and this evidence is at the time of the death of the sponsor, or before the sponsor has left the UK, and also the evidence must be for their current education in the UK. And in the case that the sponsor died, then the death certificate. Where the applicant or another family member were married to the sponsor, so then they need to evidence their broken relationship by way of a divorce or dissolution certificate. And it's worth noting that the marriage must have been, or the civil partnership must have been for at least 3 years. They must have lived together for at least a year during that 3-year period. And in terms of, and where a child is involved, then they need to evidence custody, right to access to the child. And in the case that there have been difficult circumstances, then they need to evidence this. For example, where there was domestic violence and abuse. So just to finish my last point here, where the applicant is or has been a victim of domestic violence or abuse, so then they need to produce evidence of permanently broken down family relationship due to domestic violence or abuse. And the applicant must be living in the UK when the family relationship broke down. So that concluded the slide on the application for someone who's already in the UK. So thanks very much. I will now hand over to Sharon.
Thank you, Jenny. So just on the next slide, Katie, we've included some useful links for you. So there's some on Appendix EU, specifically on family permits, so the immigration rules there, and also the guidance, and also under the EU SS scheme for pre-settled and settled status. And there's also the caseworker guidance there as well for you. And that brings us to the end of our webinar. But if there are any questions, please feel free to unmute yourself or put any questions in the chat.
Thanks, Sharon. I think there is one from Mario. I don't know if Mario wants to ask directly the question.
I've already forwarded my question in the chat, so maybe it's better if you read them for all.
Sure. I applied for EU pre-settlement scheme as a EUSS joining my durable partner who has a settlement status. I read that proving to be together since 2 years prior to December 2020 was a rule of thumb, not a strict requirement. However, after 3 months of sending my application, they got back to me asking proof of relationship 2 years prior to December 2020. We have been in a relationship since August 2019, then 4 months later COVID took place and we could not live together anymore. Hence why we have never been able to live together. What further proof of relationship should I send? And then Mario lists some of the proof they already sent. I think it's always good to keep in mind that the question and also the answer have to be quite general so that everybody can kind of take some learning from it. But I guess in this case is how to prove like a durable relationship, especially considering the impact of COVID. I don't know if Sharon or one of your colleagues.
Yeah, sure. Thank you for that question. So generally they would want to see 2 years of you living together, but obviously that isn't what's in the immigration rules. The immigration rules state that you can be a durable partner. but you do have to provide evidence of that. So, for example, in your situation where you weren't living together because of COVID, maybe an explanation as to why you weren't living together during that period of time. Was it because, you know, I don't know what the circumstances were where you couldn't live together, but anything for that. And then also for that period as well, when you weren't living together, evidence to show that you were still in a durable relationship, so that you still had contact with each other, any commitments that you had together. So you really do have to, the threshold is over and above that of, you know, it is to be akin to marriage. So over and above a boyfriend-girlfriend relationship.
Thanks, Sharon.
Thanks for your help. Thanks. Cheers.
So I can read out the next question. It's from Ayla. And it's, if you're outside the UK due to the birth of your child, what if you were not able to come back to the UK in a year's time?
Sorry, can you expand on that? So you were already in the UK? Sorry. So you were living in the UK prior to that?
Yeah, they're in Finland now, and they said yes, they were in the UK before that.
Okay, so you'd need to try and submit evidence as to why you couldn't come back to the UK. So, you know, if there were difficulties with the birth, if you had support from outside of the in Finland that you didn't have in the UK, those sorts of things.
Thanks, Sharon. And Lumturi Podramaj has asked.
Sorry, Sarah, I'm very sorry, everyone, but I need to log off now because, you know, of my family situation in the evening. So thanks very much, everyone, for attending. And I will leave, you know, the questions and answers to my capable hands of my colleagues. So thanks very much, everyone, and goodbye.
Thank you, Jenny.
Thank you.
A brief one here. Can a British national sponsor an EU national spouse under the surrender thing route?
Can you just repeat that, Ozzy? Sorry.
No, of course. Can a British national sponsor an EU national spouse under the surrender thing route?
Yes, they should be able to. I will double check that, but I'm sure that they are able to.
Thanks, Sharon. Just going to read out Claire's one now. I'm British, but lived in Spain since I was 6 years old, and my partner is Spanish, and we live together in Spain since 2019. Would I have to go before her in order to ask for the EU SS family permit? Do I have to be settled in the UK in order for her to live there too? And potentially also recommendations.
Okay, so I'm British but lived in Spain since 6 years old, and my partner is Spanish. We lived together in Spain since 2019. Do I have to go before her in order for us? So Claire, so you're British, but you've lived in Spain since you were 6 years old. Yes, so you would, ideally, you wouldn't have to come under the Appendix EU. You could potentially come across under Appendix FM, and that might be a better route for you than coming via the EUSS route. if you qualify under the financial requirements under Appendix FM.
Thanks, Sharon. So Natalie's flagged that I think one of the slides said that Appendix FM was for non-EEA nationals, but EU nationals who were here after, I believe that's 31st of December 2020, can apply under Appendix FM as well if they have a relevant sponsor. And she would just like to clarify if this is correct. Do let me know if I haven't read that out correctly though, Natalie.
Yeah, that's correct, because the slide did say non-EEA nationals, and I think it was just like a brief overview, but I'm working with EU citizens now that don't meet the EUSS rules, but they can apply under Appendix FM if they have, for example, a British child, or maybe
Yes.
they had a sponsor. So I just wanted to just make
That's
sure
correct,
people
Natalie.
know that in the slides, that was all. So I just wanted to make sure I wasn't missing something.
No,
Okay.
thank you for flagging that.
Thank you.
Thanks, Natalie. Kezia has, I believe, expanded on Natalie's point, just saying it's really important to emphasize. So again, Natalie, incredibly grateful for having flagged that to the wider audience. Wyatt and Mike Lynn, adding to Mary's question, regarding proving a durable partner, do you need to have lived together for 2 years prior to the 31st of December 2020?
And just to jump in, like the reason I'm asking is because she's in the UK as under this pre-settled status, and we've been living in the UK for 2 years now. I'm here on a residence permit from the United States, and so I'm just wondering if we need to have lived together for 2 years prior to the 31st of December 2020, or if what we're doing now qualifies.
You don't need to have lived together for 2 years prior to the 31st of December 2020, because you can rely on the fact that you've been in a durable relationship prior to that period. So you can rely on the time that you've lived in the UK as well.
Okay, so as long as we can prove the relationship from January 2020, we don't need to have lived together prior. We can just show that we're in a durable relationship.
Correct, but you'd need to have quite a high threshold to be able to show that. So it is quite difficult to show that you're in a durable relationship, unless, for example, if you have a child together, then that obviously shows that you're in a durable relationship together. But otherwise, it is quite a high threshold. So you would have to put in quite a bit of evidence to show that you are in a durable relationship if you haven't lived together for that 2-year period.
We've lived together for that 2-year period within the UK for sure.
Yeah.
I just meant prior to.
No, then that would be fine then.
Okay, cool. Thank you.
Thanks, Sharon. So the next one's a bit of a technical point, so I will read it out, but I'll ask the team if they want to maybe reserve providing a slightly detailed note afterwards, just because it might be difficult to get that out over the call in time. But Laura's helpfully set out if a family member of a relevant sponsor can apply to the EUSS once they're in the UK, in brackets, if they entered as a visitor and applied within their 6 months leave as a visitor, are there any particular benefits to them applying for the EUSS family permit prior to coming to the UK? It's not a requirement that you have to apply for the family permit first, is it?
It's not a requirement, but you might be, depending on your nationality and how you come into the UK, you may be questioned on coming into the UK. When you're entering as a visitor, you are meant to be entering with the intent to leave the UK at the end of your 6-month stay. And then also you may encounter difficulties when you apply under the EUSS pre-settled status. As Jan was saying before, there can be delays with issuing the certificate of application, so that may also cause difficulties for you. So we would always suggest that you apply for the family permit prior to coming to the UK, but it's not an absolute mandatory requirement, no.
Thanks for that, Sharon. Julia's asked a question here. I believe it's regarding some relation the application. Today, I was asked to add additional proofs of relationship. Would you recommend opening a joint bank account now? And one other thing, am I able to visit my boyfriend in the UK whilst the application is pending? Obviously, just for a couple of days, and she has confirmed that she is an EU citizen.
Judy, have you? So I'm assuming you've applied for an EU settlement scheme family permit, in which case we would probably say I recommend that you wait outside of the UK until that a decision's been made on your application. If you've been asked to provide further proof of relationship, you know, opening a joint bank account now is possible, but the amount of weight that they will give to that wouldn't be as much if you had opened it, you know, perhaps 6 months ago, for example. So it'd be worthwhile doing, but you know, the application won't swing it in your favor if that's the only bit of evidence that you have of your relationship.
Thanks, Sharon. Awa has said that she's been awarded settled status along with her youngest daughter, but she'd like to find out if her oldest daughter, who's 28 years old, is able to join as a family from a non-EEA country such as the Gambia.
So that may be possible if she is still dependent on you. So dependent children are up until the age of 21. And if they're over that, they still have to be dependent on you. And that would be quite a high threshold. So, for example, that she's not leading an independent life and that she's still reliant on you as your dependent.
I think the next question's somewhat similar, but I believe, Lena, you're referring to the Appendix FM and not the EEA route. But Lena said, I've lived in the UK for 30 years and have settled, oh, sorry, she's got settled status, apologies. Her parents are now elderly and she'd like to know if one dies, is the surviving parent able to join her in the UK?
Yes, if you have EU settled status, that is possible. Again, it's quite a high threshold for the surviving parent to come and join, but it could be a possibility, yes.
Thanks, Sharon. Marta's asked, if a sponsor's pre-settled status expires, can the family member who also has pre-settled status still switch to settled status, or would the family member need to apply for retained rights of residence?
I think we're going to have to take that one away, Marta, and come back to you if that's okay.
Yeah, no problem. Thank you so much. Thank you.
Thank you for that question, Marta. Really grateful. Laura's said most family members she's supporting are already in the UK, and she doesn't think that she's come across anyone with the EU SS family permit. She just wants to double check. I believe that might have been referring to a previous question. If that's an additional question, do let me know, Laura. Otherwise, Daniela has briefly asked, sorry, but even EA citizens need the EU family permit? That's a question, sorry. I did remember that EU citizens do not need the family permit.
That's right. It's mainly if you're a non-EEA family member that you would then apply for the family permit.
Thanks, Sharon. One other from Atta. Atta's parents, Pakistani, live in the US, they're green card holders. She'd like to know if she can still apply for them under the EU SS family permit, the EU SS scheme.
Yes, that could be possible.
Thanks, Sharon. So far, that's all we have. Ewa's helpfully provided the email address, say that if there are any additional questions after the session, to please get in touch via the email address for free advice on the relevant schemes.
Thank you.
Thank you so much, everybody. And we will send the recording to all the registered participants. And again, sorry about the technical issue which affected us in the first few minutes of the webinar.
Thank you.